Thank you, Michelle. The legal aid plan, and my department in particular is the legal accounts department. We are responsible for paying for all accounts around the province. For those clients who obtain legal aid certificates, payment of those accounts is from Toronto, and that's from my department. We have prepared a manual, and it looks like this. You need it as far as billing legal aid is concerned, and you should read it. It isn't all that complicated, but you need it as far as, especially on the criminal side, because there are a number of block fees, and the billing structure on the criminal side is mostly block fees, lesser on the hourly rate side. And so it's important that you have this at your fingertips and know how to work it. The Legal Aid Act divides accounts basically into two parts. There's civil accounts and there's criminal accounts. And it's further subdivided into standard form accounts and settled accounts. We define a standard form account as an account where the net fees and disbursements are less than $1,200, and there's no request for a discretionary increase. It doesn't matter what kind of paper you use to send us your account. If it's an account where the net fees and disbursements are less than $1,200 with no request for discretion, that is, as far as we're concerned, a standard form account. When you receive a certificate, the area director will probably send you on the criminal side, a blue standard form account. It looks like if you look at page 10 and 11, B10 and 11, that's an example of a criminal standard form account. That could help you if you want to use it. We encourage you to use it, but you don't have to. And if you don't use it, but if it's a standard form account by definition, and you use your own letterhead, that still is a standard form account. An account that is more than $1,200, or an account, whatever the value, the net value is, but there is a request for a discretionary increase, we call that a settled account. And again, you could use this piece of paper just because it says standard form account doesn't mean you can't use it. We'll accept toilet paper as long as we could read it. Because in fact it's 2-ply and we need 2 copies of the account anyways. It's a great joke. But the type of paper used is not important. It's the definition that's important. And it had a meeting a while ago, before I came on with the plan. The Law Society defines and sets certain time requirements for the Legal Accounts Department. A standard form account, whether civil or criminal, had to be paid at a percentage of 90% within 30 days of receipt of that account. And a settled account, the Law Society mandated that we had to pay up to a percentage of 80% of the accounts received within 60 days of the time we received the account. And there was a time when legal accounts was quite behind. When I practiced, and around 5 or 6 years into my practice, it was normal to receive payment for accounts 6, 7, 8 months after you sent the accounts in. And the Law Society finally decided to sort of dump on legal accounts and to impose some kind of restrictions and parameters that the Legal Accounts Department had to live up to. We are currently receiving about 20,000 accounts a month, and we are clearing those accounts roughly within 2 to 3 weeks of when we receive them. And that's all accounts, so that we're well beyond the 30 and 60-day, 90, 80% percentages that are mandated by the Law Society. But it used to have an importance. I'm very cognizant of the fact that cash flow to a lawyer is important. Because of that, when I was hired 2 years ago, I came in with a defense lawyer's, private lawyer's background, and with that knowledge that the money is important to lawyers, that what they're trying to do is service the client but also get paid. And so what we set upon doing is to sort of redefine in our departmental policies how to pay accounts quicker, and that's what we've done. It's important for you to understand, though, that the mechanics of what happens in our department. When an account comes in, it's set up, which means it's put into the computer. and then it waits, and then when an examiner is available to examine a whole bundle of accounts, the examiner takes the account, and it's given to the examiners based upon whether it's a settled account or a standard form account. There are standard form examiners who only do standard form accounts, and there are settled examiners who only do settled accounts. It doesn't mean too much, other than understanding the process, it really doesn't mean too much to you and it doesn't affect you. But what happens is that the examiner will then take the account, and the examiner will examine the account in accordance with the tariff. The examiner has no authority to pay for any amounts that are beyond the maximums that are allowed in the tariff. There are block fees on the criminal side, but there are also some maximums that are applicable, especially in type 2 and type 3 offenses, and perhaps I'll just explain that a bit. The criminal tariff is divided into basically there are summary conviction matters, there are Crown elective matters, there are type 1 indictable matters, and then there are type 2 and type 3 matters. The summary conviction, Crown elective, and type 1 matters are basically block fee matters. And regardless of the amount of time the lawyer puts in, by and large, the lawyer is paid a block fee. Excluded from that block fee are matters like bail hearings, pretrials, waiting time if a trial doesn't get reached. But by and large, it's a block fee. The type 2 and type 3 offenses are your more serious offenses, and the lawyer is allowed to bill by hourly rates for the preparation and then counsel fee for the lawyer's attendance at the actual trial or preliminary. And what happens, though, is that when the lawyer submits the account, and if the lawyer isn't mindful of the fact that there are maximums and that there are certain block fees, there are times when the account comes back and the account is reduced and the lawyer is not too happy. It is not done purposely. It's just that if the lawyer sent in the account and the lawyer has exceeded or incorrectly billed the account, what the lawyer gets back is, if you look on page B6, that's a document that we call a computer page. And we send back to you one copy of your account and this page on top of the account. And we circle that area which we advising you that there was a problem and the reasons why your account wasn't paid in full. And it could be anything from you didn't have a certificate because it was canceled, to the fact that you incorrectly billed the wrong tariff rate or the wrong block fee rate, or you didn't ask for discretion and therefore your account was only paid up to the maximums. But it's important to understand that an examiner cannot pay any more than the maximums, and they're not authorized to. What we've instituted also is, and it doesn't appear on this B6 form, is on the top left-hand corner, we've inserted our phone number and the examiner's extension number. If you need to know or want to ask a question about what happened on that account, you call that number, ask for that extension number, and if you don't get the examiner, you'll get the examiner's voicemail, and you can leave a message. Just understand that the examiner doesn't have that account anymore at the examiner's desk. You could ask a question, and if the examiner needs to get back to you by pulling the file, well, that'll have to happen. You'll have to get a return phone call. But at least you could get to the examiner who actually did your account and find out what happened or get some explanation or what's needed to correct the problem. So that was sort of a PR thing that we tried to do, and it has been working. If the lawyer believes that he needs a discretionary increase, there are times when you could do a block fee and you put in a lot more work than is required or normal for a block fee matter. Then you could bill us hourly and put in your docket. You don't have to, again, use a standard form account. You could use your own letterhead and just give us your docket. You don't have to use the manual code items if you don't want to. The examiners know all the codes backwards and frontwards better than I do. But you need to give minimal information so the examiner could actually plug in what the lawyer did into the tariff. What I'm getting at is, if it's a Crown elective offense, you have to tell us that the Crown proceeded by indictment. If you don't, we assume the Crown proceeded by summary conviction. That'll substantially reduce the lawyer's account. The standard form gives you some idea as to some of the boxes or checklists that are answers are needed, and basically again on page B10, around Item number 7, it talks about whether it's a trial, Crown appeal, or accused appeal. That's an obvious. The type of offense, you notice that there's a box for indictable, summary conviction, or Crown elective, but it asks you to fill in the blank if it's Crown elective. That's an important box to fill in if it's a Crown elective offense. Otherwise, your account will probably be paid half to what it was billed. Give us some idea as to what kind of charge it was, under what statute, whether the client pleaded guilty or not guilty, because these are things that will eventually filter down into how the actual account is paid. The outcome is important to us because there are times when, if the lawyer is asking for discretion, the results of the case sometimes speak to how much the lawyer will be paid as a discretionary increase. The box as to whether or not there was a co-accused, that helps us to decide whether or not the lawyer acted for more than one accused. The lawyer shouldn't be doing that much more because of a recent Court of Appeal case, but we need to know whether or not a lawyer acted for more than one person charged with the same group of offenses, because there's a rule that we only pay on the second up to 40%. So we need to know that. But, yes? The question was, what about the third and the fourth and so on, co-accused? When you get past the second, everything is discretionary. So what the lawyer should do is, when you're dealing with the second, and if you want to be paid even more than 40%, you should ask for a discretionary increase and give us reasons why you should be paid more than the 40%, and then so on for the third and fourth and however many accused you deal with, co-accused you deal with. If the lawyer doesn't ask for a discretionary increase, what physically happens to the account is the examiner examines it, pays up to the maximum. If it's identical to what you billed, you just get a check. And it's part of the check, on a check stub, it's just included as an item on the check stub. If the examiner authorizes less than what you billed, you will get back your account with a computer page and an explanation as to why you weren't paid. Most of the time, it's either an incorrect tariff item that was billed, but the second grouping of problems where the lawyer is paid less than what was billed is where the lawyer fails to ask for a discretionary increase. In the manual on page 5140, there is a listing of those items that a legal accounts officer will look at on the issue of discretion. If the lawyer sends in his account and includes a request for discretion, the account physically is examined by the examiner as before, but then a report is prepared by for a legal accounts officer, and the file is transferred to a legal accounts officer. And either myself or one of my deputies will look at the account, look at the report, and decide whether or not we are going to authorize any payment beyond the maximums. I could pay a lawyer whatever I want. I've practiced for 15 years. I've done a lot of criminal matters, and I read the account and I read the lawyer's letter. When I practiced, I never thought the legal aid read that stuff. I always thought that those things were missed. So what I used to do was I prepared my full docket. I then, on the assumption that things were being missed, I included my request for discretion after my last docket item, but before my totals, thinking that they had to read it to get to my total. What's important for you to do if the lawyer is requesting discretion is somewhere boldly let us know that you're asking for discretion. You could either include a statement on the first page of the account, a request for discretion is contained in an accompanying letter, or it's within the body of the account, or whatever. But let us know and sort of direct us to it. With 20,000 accounts a month, and things happen and mistakes happen, and we do make mistakes. But we don't make mistakes purposely. So let us know that something is there and you're asking for discretion. There's a lawyer in Thunder Bay who has a red stamp, and he stamps on his account requests for discretion. The problem, though, is that it's all he gives us. He just says, I request discretion. I think he just has it stamping every time he sends in an account to us. What that physically does, though, to his account is because he has requested discretion, an examiner examines it, a report is prepared for a legal accounts officer, it's passed to a legal accounts officer, and when it comes to me, I give him nothing. Because I need to know the reason why he's asking for discretion, and he has to tell me why he should be paid more than the maximums. I'm quite willing to pay anybody if their request is reasonable, but I can't pay based upon nothing. So the physical request, because of the red stamp, physically moves the account, but it doesn't give him anything, and this lawyer hasn't learned yet, and he's been doing it for a while. 5140 provides reasons why discretion will be granted, and it talks about the results obtained, the complexity, the outcome, the savings to the plan, and that usually happens where, because of pretrials, a 5-day trial bottoms out and it's a 1-day, half-day plea, and that saves legal aid money. Those are factors that legal aid will take into account when we authorize discretionary increase. But you have to tell us. You have to give us reasons why, and I don't need a book, but I need to know, because I don't know what's involved in the lawsuit or this criminal case, why discretion should be paid. Behind my back, literally, is the provincial auditor, and they come in every year. And we may be asked to justify on these particular cases why you paid discretion. I need a reason. It's my discretion, and I could say yes or no, but I need a reason. And if I have nothing there but we authorize discretion, somebody will sort of be stringing me up. So it's important, and that's the procedure that actually follows. If the lawyer forgets to ask for discretion, gets back the computer page with the second copy of the account, is told that the account wasn't paid in full because there was no request for discretion, or there was insufficient information to justify the discretionary increase, like where the lawyer just puts in his rubber stamp, you have, and the lawyer has, the ability to request a review of the account. The regulations to the Legal Aid Act say it should be done within 15 days. I don't really follow that rule as long as it's done within a reasonable time. A year is sort of unreasonable, 2 years is out of the question. So you should get it in within a timely fashion. We are clearing reviews within a month of the same month that we receive them, so that if you send in a review this month, we will have it back for you hopefully within the month of when we receive them. The same criteria about obtaining a discretionary increase applies whether or not you've included it within the account on the first go-around, or you forgot to do it and you had to ask for a review. 5140 are the same guidelines, and no lawyer is penalized because you failed to ask for a discretionary increase. Yep.
I wanted to know if the fact that you don't make a discretionary request on a certain time, that bears directly on a subsequent. Is each case looked at individually, or do you look at the case history of the lawyer? Like, is a lawyer who asks for discretion at every given instance more likely to get it or less likely to get it, or do you not even look at that?
The question was whether, it seems to me, whether or not the request for discretion is geared to the lawyer who's making the request as opposed to the case. I don't care who the lawyer is who makes the request. I look at the merits of his application and the results, the criteria in 5140, and I decide whether or not it's a yes or a no. I don't keep stats on how many lawyers ask for discretion and say, well, he's had his quota for the month and he's not going to get it. It's case by case, and there is no quota system, and I don't keep tabs on the amount of dollars spent in the week or the month because it's humongous. But
Aren't there lawyers who always ask for an increase on number, like all the time?
sure.
So it wouldn't have any bearing. You just treat each one as an individual case, and it doesn't matter how many increases he's asked for in the past.
That's great. That's right. It's case by case. I don't really care who the lawyer is who's making the request. I read the account, I read the outcome, I read the letter, and I make a decision based upon what I think is reasonable, using those criteria in my background. I mean, I know when a lawyer is snowing me. I know if you put in 15 hours on a break and enter for preparation, either it's got to be one of the worst break and enters and some huge problem, or there's something wrong here. And if I don't have enough information, I'll write to the lawyer saying I'm deferring my decision pending more information. And then I just put the file into what we call a bring forward system, and I sort of wait for him to respond or her to respond back to me. But nobody's penalized, and I don't keep quotas, and it's just case by case basis. So you're not penalized if you forget to do it in the body of the account. But what's important, that I think it's important to get across, is that cash flow, again, is central. And if you remember that aspect, and you remember that if a case requires discretion, ask for it at the first opportunity, which is when you're billing your account, The lawyer doesn't have to wait until the lawyer is paid. He gets the letter. The lawyer doesn't like legal aid anymore because we sent him back less than what he billed. He then has to open his file again. He's wasting time, or she's wasting time, reviewing the file, dictating a letter when it could have happened a month ago. And all that time, he could have been paid and the file could have been put to bed and back into records and whatever. But instead, you have to just go through the motions again. So cash flow, I think, is important. And if you remember the fact that if something needs a request for discretion, do it at the time when you're ending your account. I always, again, when I practice, I knew the mechanics of the criminal tariff, but I never concerned myself, especially on the civil side, with any of the manual code numbers. I just assumed that if something is a block fee, I knew it's a block fee. If I knew that something was a lot of hours that I put in, then I just requested discretion automatically. If I didn't need it, it didn't matter. If I did need it, it was taken care of. But it's a question of cash flow. And if the lawyer wants to be aggravated by us because we're not paying him when he submits the account the first time and wants to go through the routine of looking at the file again, well, that's the lawyer's choice. But I would recommend the former, that you do it the first time and put it to bed. You could interim bill us as often as you would like. For disbursements, we would ask that you interim bill us after $50, which doesn't take too much these days. You could interim bill us after a preliminary hearing. You could interim bill us when there are multiple charges and you've finished a couple and then you moved on to the next group that are coming up in the future. You don't have to wait until the whole thing is done. Again, that's a matter of cash flow and a matter of personal choice for the lawyer. It also saves the support staff time because it's easier to do smaller accounts than it is to do one large account. So it's a question of time shuffling and resources and, again, cash flow. But again, that's personal choice to the lawyer. When I practiced, I always was on top of my billings. To me, that was what was important to me, apart from the client. And when I practiced, legal aid was quite slow. So if you weren't on top of your billings for legal aid purposes, if you render an account and you're paid 6 months later, you're seriously lacking in funds. So I made it an important aspect of my practice to be always on top of my billings. We are clearing a check every week, at least Toronto every week. There's 4 check runs a month. It goes out every Monday, and for Toronto, you get the check every Tuesday or Wednesday. So that if you maintain a process of interim billing and keeping on top of your billings, then I think you shouldn't have a problem, subject, of course, to your workflow and your work. The money should be there. If you look on page B19, that's a copy of an account, of a certificate, sorry. When you get a certificate from the area director, make sure you acknowledge it, which means the lawyer signs on the bottom, the lawyer puts on the lawyer's solicitor number. If the lawyer doesn't have a solicitor number, the lawyer doesn't get paid. You have to get a solicitor number from legal aid, and you get onto a panel and you get a legal aid solicitor number. We could only pay lawyers. We do not pay anybody else. And to pay a lawyer, your lawyer has to have a solicitor number. So make sure when you get a certificate, you acknowledge it, you complete it, and send it back to the area director. The rough rule of thumb around the province is that certificates will expire 30 days after they were issued. That's plus or minus. And if you don't and you do the work and then render your account and your certificate was canceled, you will get back the computer page and the first item will be circled and will say to you, certificate canceled. What that means is you have to then grovel with the area director to get him to reactivate the certificate before you get back to me in my department to pay you. So make sure when you get the certificate, you acknowledge it right away. Make sure it's for your client. Sometimes you get certificates by accident that aren't your client. Unless it's a new client, you don't know about it. Make sure that the services that are authorized are what you need. My department's instructions are, and the examiner's instructions are, payment will only be made for services that are authorized by the area director. If initially the certificate authorizes a robbery, but your client, as it does on this example, but your client is charged with a lot more than just a robbery, then write to the area director and ask the area director to amend the certificate. Don't wait until the case is over because the area director may not be agreeable to amending the certificate. So that's important because if you have a certificate with multiple charges which are handled on different days, and then you render an account, even on an interim basis, if you haven't amended the certificate, we will only pay what the area director authorized, and no more. Yes?
When you request an amendment from the area director, they send it to the lawyer. They then send you a carbon copy of the amendment. Do you have to submit a copy of that amendment with your account?
Our computer system is sort of, we have one, but it's sort of in its infancy. And there are times when the amendment that you receive from the area director doesn't get into the computer in time when you send us your account. So that it's prudent, I think, when you have a certificate which has amendments and you render an account, you should send us a copy of everything you get from the area director. One copy of the amendment, just in case we don't have it in our system. Our current system is such that when an account comes in, a computer page, which you don't see, is produced for the examiner, which lists everything that is authorized, including any amendments, and including any disbursements that I'll talk to you about in a few seconds. But it's possible that something was amended and it isn't in the system yet. So just to be prudent, otherwise what will happen is if we don't know it exists, we don't make a phone call to the area director saying, was this one authorized? We see it isn't authorized and we don't pay it. And you get back the computer sheet and we say, not authorized. And we could be making a mistake, but we don't know. Yes, ma'am?
Let's say you ask for an amendment, and a week later you finish with your client. Can you send a letter like that you asked for the amendment with the account? Do you want to bill it, or it has to be?
Well, the question was whether or not you've asked for an amendment in a letter, but you haven't had an answer yet.
You haven't gotten it.
You haven't had the piece of paper received. Well, you're taking a chance if you render an account that it may not be in the system yet. So it may come back. So it's a chance you're taking. Either you wait or you try and see what happens. The next item on the certificate is under where it says subject to the following conditions. There's an effective date. The effective date is important for this purpose. Again, we will only pay what is authorized, and the effective date is important because if you do work prior to the effective date, that service isn't authorized. It used to be that was enforced strictly. It was expanded to 7 days, and when I got there, we expanded it to 30 days. So that within 30 days of that date, we will pay for services with one proviso, and that is if the lawyer has a private retainer or did some work privately for the client on this matter, as like in this case a robbery, we want to see a copy of your private account. And the purpose is to see whether or not there's any overlapping in services between what you did for the client privately and what you're doing on legal aid. It's also important that when the lawyer receives any money from the client, towards the bottom of the certificate, you have to acknowledge that the lawyer received money. And so if the lawyer receives anything in relation to the same subject matter that you're dealing with on legal aid, acknowledge the receipt of money, and when you bill the account, send us a copy of the private account. Because if you acknowledge and put a space, fill in the blank, which is towards the bottom, of the amount of money you received, and you don't send us the private account, your account will either be held up or you'll get a letter back saying, can you please send us a copy of the private account? So to avoid that, I'm not telling you not to fill in that blank. It's the lawyer's obligation to fill in that blank and send us a copy of the private account. The question is whether or not does it matter how much was received by the lawyer how much was received by the client. It doesn't matter. If you receive anything, right? If you receive anything from the client on this matter, the same subject matter as a legal aid certificate, you should send us a copy of the private account. Yes. No. I think the question, well, let me try to explain what I think is your question. If the effective date on this example is October 18th, 1990, 30 days prior to that date, you do not have to write to the area director requesting an amendment. If the services began beyond that 30-day period, then you have to write to the area director requesting an amendment and asking for the certificate to be backdated to the date that you first started working. So that I think as a prudent measure, when a file is open and it's a legal aid file, check the services, check the effective date. If there's more that's needed, write to the area director when you acknowledge the certificate, saying, here's my acknowledged certificate, please amend to add this charge, and please amend to backdate the certificate to whatever date. And then you're covering yourself. Yes, ma'am?
I have a question regarding discretionary increase. When you submit your accounts to be paid for the discretionary increase request, does that letter also have to accompany the copy of the accounts to the area director?
The question is whether or not the request for discretion has to go to the area director when it comes to legal accounts. It does or it doesn't. There's no firm guideline. In fact, there's a move to have copies of the accounts to the area director discontinued. That's soon to be announced, but hasn't. We're sort of canvassing all the area directors. But there is an obligation on the lawyer to send us 2 copies of the account and 1 copy to the client, and currently 1 copy to the area director. Whether you send the copy of the request for discretion is a call you could make. You don't have. It's not a hard and fast, and nothing turns on whether you do or you don't. Well, the act says you should. I never did. I think the only time I would send it to the client who's in custody is if the client is on a payment agreement. If the client is paying some money or the client has signed a lien with the legal aid plan against his property, well, the client then has a financial interest in how much his security is being affected. So I would send it to him if he's in custody in that situation. But if it's a free certificate, I wouldn't send it to the client. So what's the point? Yes. The question is whether or not legal aid will pay disbursements greater than what we've authorized. Can I just hold that for a sec, and I'll cover that. Thanks. Lawyers are paid an experience increase based upon the amount of years they've practiced. Lawyers starting out will receive the basic rate, and the usual basic rate is $67 an hour. And then from that, there is a deduction of 5%. If the lawyer has practiced more than 4 years in the criminal field, the lawyer is entitled to write to us and say that I'm entitled to an experience increase to the 2nd level, and the lawyer will then obtain an experience increase of 12.5%. If the lawyer reaches a level of 10 years or more, the lawyer is entitled to an experience increase moving from 12.5 to 25%. The important thing to note, however, is that we don't write to the lawyer saying, we think you've reached 10 years now and you should write to us. It's the lawyer's obligation to write to the plan, certifying that the lawyer has either put in now 4 years or more than 10 years. We don't ask for dockets. We don't ask for verification. The lawyer is certifying. We assume good faith, and the lawyer's name and computer entry tier level, which is what we call it, will be changed. And from that point onward, the lawyer's accounts will automatically be paid at the greater tier level rate, experience level rate. But the point is that it's the lawyer who has to write to us. And until the lawyer writes to us, nothing gets changed. And if the lawyer forgets to do it, the lawyer can write to us asking for discretion and saying, here's my request to increase my experience level increase. I forgot to do it on this big case. Can you help me out? And it's a discretionary call. The last item before I get to disbursements is the GST. It is the lawyer's obligation to write to us to let us know that the lawyer is registered for GST purposes. If the lawyer does not write to us and tell us that he is registered for GST and has a GST number, we do not pay GST to that lawyer. What that will then do is the lawyer's account will be sent back if the lawyer is registered for GST, and he'll be paid or she'll be paid less than what they thought they're going to receive. If it's because of GST, the lawyer will write back to us saying, this is my GST number. We will then register the lawyer, and then we will cut a manual check to the lawyer. But it's the lawyer's obligation to write to us, and we don't write to the lawyer. Yes, ma'am?
It appears to me from the legal aid accounts that I do, that GST, legal aid is withholding the GST
I don't know, that doesn't make, the question was whether or not legal aid withholds GST money and then remits it. We pay GST to the lawyers and we get it back dollar for dollar from the federal government.
Okay, so you pay then the GST that I billed on certain fees if we're properly registered.
If the lawyer, the question is if the lawyer bills us GST and he's registered for GST, we will pay you GST.
So you don't remit it on our behalf.
No, we get it back dollar for dollar. We don't remit it.
Because I've dealing with few legal aid bills, and I've recently received checks that are different in that differences in no GST.
There are.
So we're remitting it to the government.
There are some times, the question is that amounts that are paid to the lawyer is different from the amounts that were billed, and it probably relates to GST. If the lawyer's account includes some disbursements, and the person who is, for argument's sake, court filing fees, there's no GST. There are some process servers who are not registered for GST. The lawyer can bill us GST on those disbursements where the person who is rendering that service to the lawyer is not GST registered. So that there are disbursements that are with GST and those that are not with GST. And even though the lawyer is registered for GST, it doesn't mean we pay the whole thing as with GST if part of it doesn't involve a GST payment. So that could account for the fact that there was a mistake or we made a mistake, one or the other. Yes, ma'am.
Do we have, okay, on the blue form, we have a spot where we put in our registration number and the amount of GST on the fee and disbursement. Do you have to write legal aid, like, you've never written legal aid saying, I have been registered under GST, here's my number. But you put it on the Form 7, or the blue form, do you still have to write legal aid?
The question is if the lawyer hasn't written to legal aid saying this is my GST number, please register me, but sent in an account with the GST number on it. The procedure in our office is that the examiner will hold the account for a day. We will let the computer know that the lawyer is registered. Here's the lawyer's number. So the account will be held for one day. The account then comes back to the examiner, and then the examiner processes the account for payment. So the answer is no. You don't have to do it. But it just avoids the delay. If you want to send us a letter, it avoids that one-day delay. But after that, the lawyers then register continually for all accounts that come in subsequent to that date. On the issue of disbursements, the Legal Accounts Department is authorized to do mainly two things on the criminal side. One is pay accounts, and two is authorize disbursements. We do not authorize services, like we don't pay for additional charges that the client will face as a certificate is sort of live from the date of issuance. But we authorize, so that if you need something from in relation to an additional charge, you have to go to the area director. You don't come to us. If you're coming to us and you're writing to us for that amendment, you're wasting your time, because all we're going to do is pass the letter on to the area director, and if it isn't in Toronto, there may be some more delay involved in getting it to that area director, wherever the area director is. So make sure that if you're dealing with authorizing services, lawyer services, you deal with the area director. If you're dealing with a request for a disbursement, and that could be anything like medical reports, experts, forensic people, bloodstain people, you have to deal with the Legal Accounts Department. If you write to the area director, you are writing to the wrong person. And again, you're putting in a delay factor, again, in a situation where a lawyer may need an answer yesterday, and you're just causing a problem for yourself. So if you need disbursements, Chapter 4 in the manual tells you those disbursements that are pre-authorized. If it fits into the categories of the pre-authorized disbursements, you don't even have to write to us. You could just go ahead and do it. And we know what those disbursements are that are pre-authorized, and you'll be paid for them. And you're not penalized by the fact that you didn't write to us, because we've already set out the guidelines in the manual, and if it fits, you get paid. Everything else you have to write to us. If it's something that is urgent, you could get to us. On page B3, there's a listing of all the phone numbers and our fax numbers. Call us, fax us, courier us. We will give you an answer, hopefully within 2 days of when, especially for urgent matters. You may not get the answer in writing, but you'll get the answer verbally. And what the instructions are to all the people who do disbursements is that if they answer anything in relation to a disbursement and they authorize whatever they're authorizing, that information is inputted in the computer, so that if an account comes in shortly after that period of time, the examiner who looks at that disbursement will know it was authorized. If you write to us, if you fax us because something is urgent, please don't write to us after. What that does to us is it causes us to look at that file twice. And we are, the people who are dealing with disbursements are under instructions that if a lawyer faxes us, we fax them back, on the assumption that if it's important for the lawyer to get to us and get information quickly, then we'll get back to the lawyer quickly. It is important to understand, and for the lawyer to understand, that it's the lawyer who is hiring these experts if it's an expert you have to hire. It isn't legal aid who's hiring the expert. The liability, and in getting specific to your question, the liability for that disbursement is not with legal aid. If we authorize 50 hours of a private investigator at $50 an hour, if the private investigator comes in with an account of 75 hours at $100 an hour, that's the lawyer's problem. We provided the lawyer with an authorization of 50 hours at $50 an hour. It's up to the lawyer to monitor that private investigator or monitor whoever they hire, because the person who is contracting with that expert or with that person who is retained is the lawyer, not legal aid. Yes?
Will you still pay the $50 for the hours and we pay the extra $50 for the extra 45 hours?
The question is whether or not we'll pay at least what we've authorized. Well, we certainly will. And that isn't to say you can write to us again saying my private investigator has just about exceeded the 50 hours and needs more time. The point is, deal with us. Don't assume that we're just going to retroactively agree to authorize more than what we initially authorized. We may, but you're taking a chance, because our obligation ends at our authorization. And that's what we will pay. The rest is discretionary. And if we think or take the position that what the person did subsequent was unreasonable, then we won't pay it. The question as to whether or not the client could pay the difference, that's a dicey question, because it affects the client's eligibility for legal aid in the first place. Especially on the civil side, we have agreements with psychiatrists and psychologists as to their hourly rate. And it's also part of their professional ethics and professional responsibility. If they accept a legal aid retainer, quote, they cannot collect from the client to make up the difference of what their normal hourly rate is. They are accepting legal aid rates, and they can't bill for the excess, because they basically are like OHIP. You can't bill privately on top of OHIP. There are some rare situations where we allow it to happen, but again, it's a discretionary call. It's not an automatic call. But the important thing to remember about disbursements is that legal aid will authorize everything that's pre-authorized, and you can go ahead and do it. You don't have to write and waste your time. For those things that are not pre-authorized, what we'd like you to do is get us, especially on the big cases like murders and that, where tons of money is spent on experts and forensic stuff and that kind of thing. It's important to get us an idea as to what is needed, how much time is needed, what the person's hourly rate is, whether the person is within the country, because a lot of times experts are flown in from the United States. We would ask the lawyer to canvass whether or not there's similar experts in Canada, similar experts in Ontario. And those are bits of information we need to know, apart from the reason why the request is being made, so that we can make a decision as to whether or not we think that the request is reasonable. But it's the lawyer's responsibility to monitor that expert or that person who was hired, so that if more time is needed, write to us or fax us. Don't take a chance that we're going to automatically agree to pay the excess. We may not, but it's why put yourself in that position? Because there are times when we don't pay, and then it's the lawyer's responsibility to pay it out of his own pocket. Just last, yes? I have lawyers who, the question is whether or not we could answer questions that are urgent quickly. We do. I just tell the lawyer that we don't get, you won't get your letter in 2 days, but a lot of times lawyers call me and ask me directly for authorization. And I have a computer on my desk. I call up the file, and I basically look at it without even seeing the physical file. And I make a decision, and then I input the information on the computer right there and then. I tell him it's been authorized. And if he wants to save me a step, he could confirm to me what we've just talked about. But it's there. That way it saves me. I don't have to do anything. But I've already put it on the file. The question is whether I take into account the complexity, the seriousness. Of course I do. I mean, it's a general mix based upon my background. I mean, and the lawyer tells me on the phone what's involved, what he needs. There are times when these big cases that are going on, there's no maximum that will be authorized on a particular case for disbursements. Every case is different, and I just use my background to decide whether or not something is reasonable. I rely heavily on the lawyer because the lawyer is the one who's the front person and is doing the work. There are times when I think the lawyer is out to lunch. and I'll tell the lawyer, I don't think this is reasonable for public funds to be spent in this fashion, and convince me, or I'm going to say no. But it's a judgment call you make on a daily basis. Yes, ma'am.
We have a civil procedure matter going on right now, and we are authorized to the order a letter stating that the case is for 2 years and we have proper period of 5. We've now been told that the certificate has been canceled. Approximately, there's been $600 in disbursements. Are we able to take that?
The opinion letter you sent was sent to the area director. The legal counsel department doesn't always receive copies of opinion letters. In fact, the majority of the opinion letters don't come to us. If the area director authorized the lawyer to proceed to a certain point, then the lawyer will be paid up to that point. If within the confines of that time frame, disbursements were reasonably spent, then they'll be paid. If you carried on after the cancellation date and proceeded to complete a divorce, say, and set it down and spend more money, then you won't be paid because you weren't authorized past that point. Yes?
Preliminary inquiry, is that an authorized disbursement? I know to get a copy of the transcript of the preliminary inquiry, if the guy wants to go, say you've gone to preliminary inquiry for 3 days, and the guy's sitting in the jail, and he wants to review the 3 days, if we photocopy that, can we fill that as an authorized disbursement?
The question is whether or not a preliminary hearing transcript could be obtained for a fellow who just wants to see what happened for 3 days. You could order a transcript. We're assuming that the lawyer who orders the transcript needs it for some reasonable purpose. If it's simply to give the client something to read, one, we have to, first of all, know that that's happening, and we may not know that that's happening. But the fact that you need a transcript is something that's pre-authorized. We just hope the lawyer will exercise reasonable discretion.
You need the preliminary hearing transcript, because you're going on further. But then he wants just a copy of that, so if you photocopy that, 3 days of photocopy to add up,
Oh, the question is whether or not you should Xerox a copy of the transcript. Well, I don't think that's proper to Xerox the copy because the reporter probably has some kind of copyright in it. I mean, I know it's done all the time. But technically, I should say you shouldn't do it. But we wouldn't know what you've done, basically, because part of your account, will say you put in 45 pages for Xeroxing at 10 cents a page. If your office cost for Xeroxing is greater than 10 cents, then you're sort of taking a hosing on whatever it costs you to do that. But we wouldn't really know. If there's like 1,000 pages, we may ask you as to what this was used for. I mean, something has to jump out at the examiner before that kind of question is asked. Yes. Yes, sorry.
I just wanted to make a comment that as a court reporter, I hope that nobody in this room has ever photocopied the transcript.
And I'm sure glad I said that, too. Really. I knew you were here. That's why I said that. Yes, ma'am.
In regards to disbursements again on experts, if you have an expert that is billing disbursements on top because for example, we may have more hours on the psychologist is billing 6 something per hour in certain cases. If that expert has disbursements on top of that, for example, can he bill that to us and then we
The question is whether or not an expert who's authorized, let's say up to 4 hours to do something, could bill some kind of overhead expense. We don't pay overheads to lawyers. We don't pay overheads to experts. Typing kind of thing is like office expense, and that expert should eat that himself or herself. But not like travel time and mileage. We'll pay that because we pay a lawyer that, but we won't pay office expenses. I've been.
I hate to cut Arnie short. I'm sure he has lots more he can tell you, but we do have another panel for you waiting in the wings. I don't know what Arnie's schedule is, if he is going to be able to stay until the lunch break or not.
I'll stay.
If he can, maybe those of you who do have questions that haven't been answered so far can speak to him when we break for lunch and still leave yourself and him some time for a quick lunch today. I want to thank Arnie very much for joining us.
Thank you.
Thanks, Lauren. Our next panel is a topic that's near and dear to the hearts of most criminal lawyers, and that is coping with clients. I'm pleased to tell you that we have with us today as the moderator of the panel, Stephen Skurka. Stephen is a partner in the very well-known Toronto firm of Cooper, Sandler, West and Skurka. He's really had a chance to see this area from both sides because Stephen, before he became a member of that firm and now a partner, was a Crown attorney for some years, working out of the North York office in the north end of the city. So he's now had a chance to both be involved in dealing with clients himself and also perhaps to stand back and watch lawyers and support staff doing it from a slightly different perspective. Along with Stephen, I'm very pleased that we have with us today two very experienced members of the support staff community. Stephanie Mealing, who is seated to my immediate left in the green dress, is a very well-known member of the Criminal Lawyers Association in the sense that she is presently its executive secretary, and again, some of you may have had dealings with Stephanie in that capacity. But Stephanie has also been involved as a member of a support staff in private practice now since 1965, working in various offices, but most notably with William Trudell since 1982. And in her time, I know that she has had to deal with many difficult clients and many difficult questions. At my very far left in the red top is Marie Mountjoy. When I first met Marie, she was working at the College Park Courts as a senior court clerk. She was supervising judges' staff and also acting as a trial coordinator there for a period of time. And then somebody saw the light and realized that Marie would be a very valuable resource to have in a private defense practice. And as a result, around 1987, Robert McGee, also a very senior member of the criminal bar in Toronto, was able to lure Marie away from the courts, and she joined his practice and that of Krzysztof Preobrazhensky, working as a law clerk and legal assistant. And Marie, I know, also has a great deal of contact with clients and has told me that she spends probably more hours than she can count meeting with clients both in the office and out at the jail. So I'll turn the next panel over to this group of very accomplished and knowledgeable individuals.
Thank you very much, Michelle, for the introduction. I should say at the outset, we want to encourage questions both during and at the end of this session. So please feel free to put your hand up at any time and share with us particular anecdotes or particular questions that are on your mind. I'm going to turn first to Stephanie and ask you, Stephanie, what are some of the issues and questions you deal with regularly when you have to cope with clients?
Well, first of all, as most of you are aware, criminal practitioners are out of the office most of the time. So the job of maintaining contact with the client falls upon you, and communication, of course, is the key. and you are the only link, between the client and his lawyer. So first of all, I want to start off with how to deal with the first initial contact with a client out of custody. This is a client who's been released on his own recognizance, and he phones your office. The first thing I do is tell him not to discuss the facts of the case with anybody else, and of course make an appointment for him to see the lawyer as soon as possible. And you just generally try to make him feel that you're there to help him. And then we go to the telephone call from the police station. Now, this is a really kind of a difficult area because depending on your level of experience, some counsel will want you to handle these calls and some won't. If the lawyer that you're working for doesn't want you to handle it, then of course the first thing you do is give them duty counsel number. But you run a risk there of losing the client. But if you are asked, if your lawyer does want you to deal with the client, then find out first of all, the client is to be told that he has the right to retain and instruct counsel, and he doesn't have to make a statement. But you have to be really careful with this. You can't just say to the client, "Don't say anything," because that could be construed as trying to frustrate the police in their investigation. So you have to be really careful how you say that. You just advise him that he's not obliged to make a statement until he has spoken to counsel. And then what I do is I ask to speak to the arresting officer and find out whether they intend to release him on his own recognizance, or whether they're going to hold him for bail hearing, when the bail hearing is going to be, what courtroom, and so on. And once you find out all that information, ask to speak to the client again and explain to them, because for the most part, they're terrified, and there really isn't much you can do for them other than try and take some of the mystery away. That makes them feel a little bit better. Yeah.
You get a call at 2 o'clock in the morning, client saying they want me to blow. Lawyer doesn't want to be called at home. What do you tell them?
Well,
No, you go ahead.
No, I don't know that you would do anything more than phone the lawyer at that point, or try to get.
I mean, I told them that they have the right not to do it, but if they don't, they can be charged. But can you do anything other than that?
I think that the reason I'm intervening is because I think that that's really outside the ambit of what support staff should get involved with. Now you're giving legal advice, and I really think that you have to be careful not to intrude in that area. And that's the reason. That really goes outside the parameters of what Stephanie's talking about.
Another very important aspect when you receive telephone calls from clients is don't ever discuss the facts of the case over the phone. A client should also be told not to discuss the facts of the case with anybody else other than their lawyer, and this goes directly to solicitor-client privilege. He may discuss the facts of the case with a friend. The police might find out that he's discussed the facts with a friend, and the friend could be subpoenaed. So I always advise them never to discuss the facts until they come into the office, or ever at all. And secondly, while the events are still fresh in their memory, it's a good idea for them to make notes as best they can remember. Because as time goes on, months go by, preliminary hearing comes along, trial comes along. Sometimes the memory isn't so fresh anymore, so as soon as possible they should sit down and make notes. And if they have potential defense witnesses, they should be advised also to have them make notes, independent of each other. But as Mr. Skurka has advised me, it's very important that they put on the top of these notes, this is for solicitor or for lawyer only, so that nobody else has access to these. They can't be subpoenaed. Okay. Set dates. Lawyers have real differing views on this. Some lawyers really insist that a representative be there to set the date for the client. Others don't have a problem with sending the client with a letter. There's several different types of clients. There's the clients that repeat offenders, have been around, know the system intimately. They don't have a problem with going on their own. And then there are the people who've never been arrested before, who are absolutely terrified, and they really need somebody there to hold their hand. So this is a decision that the lawyer will make. From my experience, I've always found that it's not a good idea in most cases to send the client with a letter, although sometimes it's absolutely necessary. But anything can happen at a set date. You know, for instance, the information might not be there. How does the client know what to do? They may get there and they may find that there's some new charges laid and they're being arrested. And sometimes how can you be sure that the client is going to behave themselves? You know, I mean, anything can happen, and this is just my personal opinion. I think it's dangerous to send a letter, but sometimes you really don't have a choice. And another problem with sending a client with a letter is if they don't phone you back and tell you the date, you know, and if it slips by you, you know, there's a very real danger of contempt of court citation for not attending. And in that case, you have to order the information, look at the back of the information, as Ms. Corrick has suggested earlier, make sure you know what court, what date. And it's always a good idea to order the information in any case, because it'll give you all the information that you need for ordering disclosure and stuff like that. So that's basically the initial contact with the client, you know, and then as far as the ongoing communication with the client is concerned, law practices that are extremely busy, they have a tendency just to see the name, the court date, the charges, and they kind of forget that there's a living, breathing person attached to those set of facts. So it's important to always, you know, remember that the client has to be treated with respect. And you always have to communicate. It's very important to communicate with the client. For instance, a client hires Mr. X to represent him in court. He shows up for a set date or any kind of preliminary situation, and he's expecting Mr. X to be there for him, and Mr. X's junior or student shows up. And sometimes the clients get upset by that. They say, I hired Mr. X to be my lawyer, and every time I show up in court, there's a different face. And so it's really important to always communicate with the client and, you know, phone them ahead of time and just say, this is going to happen tomorrow, and it's not necessary that Mr. X be there, but this person's going to be there, and this is what's going to happen. And that really makes them feel a whole lot better. If they know what to expect, then they very rarely ever get upset. And it's important to keep the client involved all the time. And you'll see in my paper when I call a client, even if it's at my own initiative, I always say, Mr. X asked me to call you and tell you this, because it just builds confidence with the client to let them know that the lawyer is thinking about their case, and because they have a tendency to think that this is the only case that the lawyer has, you know. And so often the complaint is, I keep phoning my lawyer, he doesn't call me back, right? So a support staff member should call the client back and just say, he's unavailable right now, he's involved in this or involved in that. Is there anything I can do for you? And I'd be happy to take a message and give it to him so that he knows what your problem is, and he'll get back to you as soon as conveniently possible. And again, nothing should ever be discussed on the telephone. Okay. A client will very often ask you questions like, what's going to happen to me? And it's really crucial that a member of the support staff never give legal advice. Yeah.
Try and make the person feel more comfortable. Do you think it's brave for me to say, well, you know, I assume your sentencing is not going on tomorrow, but I don't know, you better talk to your lawyer. Can you just throw in a little something and then qualify with them, you know, I'm not a lawyer, or I don't know, but this is what may be happening? Because quite often you might know that the matter's being adjourned.
But you don't want to say that.
Yeah, you don't want to say, well, don't worry, the matter's not going to hit tomorrow. And the person's all freaked out, oh, what am I going to be put to jail tomorrow, or something like that. Are you allowed to sort of, or do you think it's proper to sort of try and tease them a little bit, qualify with, you know, I wouldn't know, but, you know, perhaps tonight Mr. So-and-so.
What do you think, Steve?
Well, I think sometimes you can create more damage than good by doing that, because you might not be aware of the reasons. For example, in an adjournment, there might be very good reasons, and when you tell the client the case is going over, they might be more of a quandary than before they made the phone call. So I think my view is that you're best off just assuring the client that you will communicate it to the lawyer and assure him that or her of the importance of the message, and that will be conveyed to, and then leave the actual content of the message to be communicated by the lawyer. I think that's the safest course of action. That's just my own view.
case where you have a young offender or an irresponsible adult whose parents are actually paying the matter, want to know what's happening, and they're calling and want to kind of make sure there's a standard phrase that you can rely on.
Well, I'll leave that. That's
Yeah, I don't think that you should be relaying information to anybody other than the client, regardless of who's paying the bill. And
What if the client's irresponsible and you think you might not show up to court? And let it call us,
Well, again, I suppose the same point would be that would be the lawyer. That should be the lawyer's responsibility, unless you have a communication from the lawyer in advance, and he or she tells you, look, if the parent phones, please let them know that the case is up tomorrow. But I think, again, you run into the same problems indirectly as opposed to directly. The parent might wonder, why is that going over? Or what's the reason for that? They'll start challenging you, won't have the answers, and then, of course, I think it's the safest course of action. That's my view. Yes?
I know for myself, I had a very bad experience. I was told to tell the client that the case was being adjourned the next day, and I did. I wasn't told that the client had to appear, and the client was charged with fail to appear.
Mm-hmm.
And it was a real bad, it was really embarrassing on my behalf, and the client was very upset. And I guess I've learned the hard way that the safest thing is, well, you have to stick to the lawyer.
Mm-hmm.
Even though the lawyer told me to say that, when the client calls, tell them everything's okay, the matter's going to be adjourned.
Right. We planted that question. Okay. Anyone else? Do you have anything else to?
there's just a couple more points. As I said, you're the link between the client and the lawyer, and you have to convey a sense of confidence. But there's a real problem or a real danger of becoming too emotionally involved in the situation. It's not really a good idea to give the client the feeling that you're his confidant and his best friend and he can tell you anything. You can be sympathetic and you can be as helpful as you can, but always be professional. Don't get caught up in their problems because that creates a real danger. And the other point I wanted to make was dealing with the press, which is really a problem. It's always been my experience, say nothing. These professional reporters have real creative ways of getting information out of you when you might not even realize that you're giving it. They construe certain things out of things you say. So I found that unless there has been a lot of media coverage of the case that you're working on, it's better not even to confirm that your firm is acting. Just say less as opposed to more when it comes to dealing with the press. And of course, papering the file is really important. Every phone message should be documented, every memo of every meeting and everything, just so that everything is complete in the file. As time goes on, people can refresh their memory, and there's no loss of recollection. And also, that's very helpful when it comes to the end, when you're billing out the file. And I think basically that's all I have to say, other than communication is the key. And, their clients, sorry.
No, go ahead. There's a question here and then here. Go ahead. Did you have a question? I'm sorry, go ahead then here.
What happens when you know that your lawyer is not going to talk to his client before court and he's calling?
What lawyer would do that?
Putting the call through you, and you're sitting there and you know exactly what's going on, and what do you do? I mean, they're saying, I paid Mr. X, and I'm not getting to talk to Mr. X. Like, what the heck's going on?
I don't know what you do. All I do is just say, I'll give him the message. What else can you do? What else can you do?
Well, I can tell you just from my own knowledge that the Code of Professional Conduct requires lawyers to respond to telephone calls from clients. So now I don't say that's the ideal, and I don't say it's always put into practice. but I know our own staff, support staff is here, so if I wasn't answering my telephone calls, they'd be saying something right now. So all I can tell you is it's unprofessional and should be done, and if it isn't, really, there's nothing that can be done.
There's a question.
Yes, over here.
I have a feeling that it's, I don't know if this is right, it's always better to have a degree of, not have the client know too much about you, or like a last name, or your name. I worked for a lawyer once. She insisted in correspondence that she put down my name, Mrs. So, or my secretary, you can contact Mrs. So-and-so. And I didn't like it, and, you know, she said, no, it's important thing before. I don't really think so, because, you know, there's times about people that would send us letters that, you know, they might have a mental problem, and you could in no way have told them that all of a sudden they could, you know, want to take you away somewhere with them, or promise to come and visit you at the office. What would you do in a situation like that, if somebody expressed to the lawyer that you really don't want these people sitting as criminals, right? You really knowing who you are.
I think you have the right not to allow the clients to know your last name if you really don't want to.
Yeah, I would agree with that. Would you, Marie?
I prefer that they don't know my last name. There are some clients that you get to know, those clients are facing more substantial charges, and you sort of build up a working relationship with them over a number of time, and you go to court with them on a set date, and they hear your last name being given in court. But as a rule, I would prefer that some of the clients not know my last name. We have a few clients who firmly think they're being prosecuted by the CIA and leave correspondence at the office to that effect, that the CIA are now camped in their backyard. And I know it's not the CIA, it's got to be the Boy Scouts. But those clients, you definitely don't want them to know your last name. I guess by now, at this point in the morning, you've gathered that there really are no lessons on how you learn to deal with the people that you're dealing with. You learn from your principals, you learn from your employers, you use your common sense. And yes, some of the things these people have done are horrific, but it's not your place to judge. When John Doe phones your law firm or your principal and says, I'm interested in retaining Mr. McGee, for instance, not only does he retain the services of that lawyer, he retains the services of the support staff, because together you make up a team. And if your office isn't operating that way, then perhaps you should look to clarify your role in that office. You're not just a secretary. You're the person who mans the fort while the boss is in court. Or if you're the type of secretary who does legal assistant work or law clerk functions, and you're in court in the morning as well, you're a visible part of that team. You're appearing on behalf of your principal, and you're setting a date, or you're arranging disclosure, or the Crown may relay a message to you because they know you and trust you and know that the message will be reconveyed to your principal. But nobody's taught us how to do any of this. I didn't know a thing about criminal law when I started to work in the courts. In fact, I was terrified of swearing in witnesses. Swearing in accused, just handing them a Bible was traumatic. But after a period of time, you learn to divide your personal feelings towards these situations from your professional responsibilities. And the responsibility is that of providing a legal service. And you don't have to be really intense about it. If you have a sense of humor, that will get you through the worst of any situation. And there are times when your clients, at the end of very lengthy trial matters and procedures, your lawyer is exhausted, you're exhausted from running around preparing case books for the lawyer so that he can get his submissions together, and from perhaps putting in a few extra hours as they do charges to the jury. And at the end of it, there isn't always a sense of elation. Sometimes there's a bit of a sense of loss because you've gotten to know this person. He's not just file number 10,050 for 91. He has a name, and you know a bit about the family, and you've delved a little bit more into their background as the defense has rolled along. That's part of this whole process. Stephanie raised the issue of not becoming emotionally involved with your clients, and that's tough to do, but that's something you will learn over time. And it's a painful process, but each step of the way gives you more experience, gives you more confidence, and makes you a more valuable asset. The whole purpose of having secretaries and law clerks and legal assistants is to provide a better service. Most of us, if we go to a doctor, you know something about the doctor, or your girlfriend might go there, your husband's been there, or you know, a coworker has been there. So you have a feel. A lot of times when you retain legal services, you don't know anything about the person. Your recollection of that individual might be what you see on the news. If it was a well-publicized case and every day the lawyer's face was on the news, that may draw that individual there. So some of the work that you do is to quietly bolster the client's confidence in your principle. One of the issues that we covered was, how do you deal with when the client says to you, "So you're a good lawyer?" You know, the standard answer is, "I wouldn't be working for him if he wasn't." That I've done that, and I've used that approach with certain clients, but in other clients who are facing charges that are quite serious, I've often told them, you're the one who has to make that determination. You're the one who has to know whether or not you feel comfortable with this individual. Is the lawyer brusque with the client? Get him away, I'm not answering that call. Or does the lawyer show some sort of concern? But the evolution of the client relationship is something that just doesn't happen immediately. It's something that takes place over time. It doesn't matter what the charge, it's something that evolves. So you will evolve as you learn how the process works. I had to. I'm sure all of you can as well.
There was a question over here, Marie, but just interrupts.
One was, it was in an area that when the client would come in, the secretary was in view of that client, so they would talk. The client came in quite regularly. And then it was quite interesting. Just because she listened to him, after the matter was over at court, he didn't leave her alone. I mean, the police had to be called because he was calling her all the time. He was harassing her constantly, just because she listened to what he had to say. A lot of these people are very lonely, and
Yes.
you give them the slightest bit of attention, and I mean, it was frightening for her, because she'd walk out on the street and he'd be a block away, you know, standing there waiting for her. And you didn't know it, not that she felt that he was dangerous, but still, she was always looking over her shoulder.
I think
6 or 8 months after.
I think that all of us have a sense of intuition. You know when a situation just doesn't feel right, and this client may give you a bit of the willies, and you're better to always be cautious in that type of situation. I've had clients who I think, or Mr. McGee or Mr. Pribozhinsky have had clients that have literally frightened me. And at the end of the whole process, a huge bouquet of flowers arrives. And I'm thinking, is it ticking? And inside it will be a little note saying, "Thank you for your patience and your understanding. I know I probably wasn't the best client." And those have come from both men and women. Not unsolicited, you know, totally unsolicited. But it's just those particular difficult clients. You've raised an issue of people who are suffering from mental difficulties, and I think most of us.
Individual who you would never, I mean, I saw him in the reception area frequently. You never, you know, I think the ones that show that they're a little bit odd, I mean, you're much more careful. But I think that was an individual that you wouldn't have picked it up at all.
We had to have an addition made to the office to hide a particular secretary. When you come into our house where the law offices are located, it's glassed in and it's reception. But one particular secretary was sort of at the peak, and they had a custom-made divider built so that clients could not see her, because clients would routinely ignore the receptionist and just go barreling into the office. And it was inconvenient to keep locking that door. But the problem was solved by building this very nice divider for her, and allows her a sense of privacy without people staring at her, especially the clients that are fit into the "I'm not so sure about" category.
Well, this other person in her office also was there by herself one day. All the other lawyers were in court, and the secretaries were in. And this client came in, he was a hardcore type.
would have got up and locked the door. Prior to that point, if I knew I was going to be alone in the office, especially if your offices are downtown, lock the door, you know.
Let me direct a question. Did you have more to say, or is that okay? Let me direct a question to both of you. First to Stephanie, and then to Marie. One of the unique features that I see at criminal law support staff is that when the client walks in, he or she comes in with baggage, and that baggage is the crime that they're charged with. And often is the case that that crime can be quite serious, quite egregious, shocking, child abuse, sexual assault of a serious nature, horrific violence. Do you find that there's any problem that you confront in dealing with that client, knowing some or all of the allegations they're confronted with, and how do you deal with that problem?
Well, as Marie mentioned earlier, it is very difficult when you have a real horrendous fact situation not to be horrified in some cases. But the bottom line is that it's an adversarial system, and you know, they're entitled to a defense, and you just try not to be judgmental until the rubber hits the road, sort of thing.
Let me ask you this, Marie. When a client walks into the office, you've already referred to one of the questions they'll ask commonly, which is he or she a good lawyer? Are there any other kinds of questions that routinely confront support staff that you can think of?
Well,
and how do you answer them?
There are a number of questions. Generally, they like to know the process, or how long is this going to take. And this was much more common prior to the Askoff decision, when in Brampton you could be, you know, dallying around with a theft under charge for 18 months. They like to know in terms of, like, how long is it going to be to my preliminary if I'm facing robbery charges or trafficking and narcotics charges? What's going to happen there? What's the purpose of that? Well, what did the police say I did? And I think it's easier for your clients if you have some sense of how the court structure works. Like, first time you go to court, you set a date. You'll be adjourned for 3 or 4 weeks pending receipt of this. And if you can break it down into time periods for them, it sometimes makes it easier for them to deal with. There are some clients who are habitual in their criminal activity, who don't care. They couldn't care less if it took 6 months or 6 years for their matters to be resolved. But there are other clients who want to know. The uncertainty of it is real tough on them. They're scared by the process. It sometimes means losing a job or losing a home, losing a privilege, be it your driver's license, those type of things. If you can break it down, let them know how the system is going to work or should work at its ideal, then they're more confident, they're more relaxed, and more likely to leave you alone.
So there's the structure of the courts and the process, and then there's the other question of the counsel's competence. Any other questions, Stephanie, that you can think of that you have to deal with regularly?
Oh, there's a number of commonly asked questions that you're going to have to deal with when the lawyer isn't there. Well, for instance, can I call the complainant at home, or can I call a witness? I missed my court date. What do I do? What happens if I don't report? There's a whole list of commonly asked questions that you should probably be speaking to the person that you work for ahead of time and just say, what do you want me to say in this particular situation? You know, so that you're sort of forearmed when the client calls.
Should support staff be in a position to advise prospective new client about the range of fees that he or she is likely to confront?
It's never been my practice to do that. I leave that to the lawyer.
I don't do it unless I'm specifically quoted a fee within a certain range, because there's no way you can generally know in advance or on an initial interview exactly what's going to cost, whether or not you need to hire an investigator, or whether or not you have to have an accident reconstructionist attend, whether toxicologist services are going to be required. So if they ask, and the lawyer has sort of given a standing figure or a ballpark figure, say, well, his fees may range from this amount to this amount plus disbursement, but the final fee agreement is subject to his discussions with you. But that's only on a standing communication from your principal. It's not a figure that I would sort of pull out of the air.
Does that change at all or vary if the particular lawyer's on a holiday, vacation for a prolonged period of time?
Well, generally, when they go on vacation, they may indicate the same sort of thing. The difference when they're on vacation is you'll get clients who are very anxious, want to come in immediately, an hour after the phone call is made to see you. And we generally make provisions in our office to let that potential client know that Mr. McGee or Mr. Preobrazhensky's out of the country on vacation. If you like, you can set an appointment with the law clerk prior to your first court appearance. And quite often, they will meet with me and I will do the initial intake interview, gather the facts, the personal history with regard to that individual, their background, their criminal record, whether or not they might have an alibi, which sometimes comes up. I will get as much facts as possible, prepare a memorandum to file for that particular counsel so that when he returns, he can go through it, know exactly what the client's facing. If he has questions about my interview with them, he can raise specific points with that person. He knows exactly where to address the issue. And it makes the client feel that their interests are being taken care of from the very beginning. And I've had more clients wish to meet with me than I've had to say, no, I want to talk to the lawyer.
Now, we've dealt with the situation where the client telephones from the police station or in custody initially. Of course, we know that there are many clients who will be in jail, either detained pending their trial or awaiting a bail hearing or a bail review, and those calls come in from the particular detention center and they're collect calls. Could I ask both of you what support staff should do when those telephone calls come in from the jail, and what are the things to keep in mind? If I could just ask whichever of you chooses to comment.
Well, first of all, I never, ever refuse a telephone call from the jail. This is for the most part, it's the client's only contact with the outside world, and they sometimes have to wait in line for hours just to get to the phone. So for them to call your office and you say, no, I won't accept the call, it's pretty devastating. But there again, it's always collect calls. We're talking 75 cents a piece, and sometimes the clients call every day, a couple of times a day. It's important to keep track of the amount of money that's going on your telephone bill when it comes to billing out at the end. But you know, just be as helpful as you can, but by all means speak to them, even if it's just that they want to hear a voice from somewhere outside of the institution. Yes. Mm-hmm. Yeah, and that's as long as the client knows ahead of time that that's your practice, then I don't see anything wrong with it.
That's an excellent idea.
Yeah.
Now, some of the questions that you may be asked in these kinds of calls include questions of bail, medication, questions about getting money, sending messages to family. How do you deal with those kinds of questions, Marie?
Speaking of medication, I had an instance of it yesterday with the East Detention Center where a family member was yelling that their relative who'd just been sentenced to a year was not receiving medications. I checked with the medical unit, spoke to the nurse, and said, we've had this complaint. She said, just a moment. And when she investigated it, she found out that when the inmate was being processed and going through the medical admission, that he told the nurses there that he had no drug or alcohol problem, was not on any form of prescription drugs, and was in perfect health. So when the family member phoned back to inquire as to the outcome of that, I advised him exactly what the nurse had told me. And there was dead silence on the end of the phone, because some people will go to very extreme lengths to get things like Valium and Quaaludes and things that are marketable in the institutions. So you have to be very careful that you don't sort of jump all over the institution, because they're doing their job as best that they can. Family members, if they call with regard to information, we tend to be rather circumspect. The client is the client. His mom or dad or aunt or uncle is not not the client. They have an interest in what transpires for their family member, of course. But I don't give any information outside of perhaps a court date or advising them we've scheduled the bail review for this date. I understand you're going to be surety. And it's Mr. McGee's intention to call you as a witness. Could you please be, at the General Division Courthouse at this time? And that's, I let Mr. McGee determine how much information he wishes that particular family member to know about a situation.
Okay. We're getting close to the end of the session. I do want to be sure that we deal with one particular area that I'm sure you're all aware of, and that's the difficult client, how to deal with that particular kind of client. What are the kinds of things a difficult client might do, and what should support staff's response be, Stephanie?
Well, sometimes it's necessary, if the client is being really abusive, to just tell him to stop, and tell him that if he's not going to stop abusing you, then you're just going to hang up, and if it continues, then you have to do it. Another method that was explained to me a couple of weeks ago, which I thought was a really good idea, was if a client is screeching at you, swearing and being terribly abusive, you say, could you just slow down, because I want to take this down word for word, right? Because I don't want there to be any mistakes when I pass this message on to the lawyer, and then you repeat it back to him so that he knows exactly what he said, no matter how profane. And that usually stops them right in their tracks.
You'll know they're really insane if they keep doing it. Yeah. Okay. Any comments on that topic, Marie? Now, you'll have clients on a serious note who really are abusive, but it's not their fault. They have a psychiatric problem, and those are probably the most difficult clients, speaking from my own experience, to deal with, because you can't confront them on a rational level. And I don't think there's any answer to that other than just using ordinary common sense, but at the same time exercising precautions, because some of these people can be very dangerous, and I'd alert you all of that. Anyways, I see we're at the end of the hour, and I want to thank all of our panelists, and thank all of you, and wish you all a happy Secretary's Day.
Thanks, Steve and Marie and Stephanie. We're going to break now until 2 o'clock for lunch. Please come back. We've got lots more for this afternoon's session. Some of the questions which were raised on the last panel are going to be dealt with from a little different perspective in the ethics panel, which is the very first panel after lunch. So if you have questions that you feel are related but perhaps a little bit different to the issues we've just discussed, please feel free to pose them to the next panel.